I really mean that literally, saying 5-alarm fire, that I have been doing equality and human rights legal work for almost 40 years. That is to say, before lesbians and gay men had any legal protections whatsoever, and at a time when 25% of the laws of British Columbia explicitly discriminated against lesbians and gay men. So, a bad time, right? Not as bad as it is now. I have never in my life been so frightened. And the reason that I'm frightened is because, and we'll talk about the detail of this, because of the lengths that politicians are prepared to go, and the trade-offs that they're calculating. So what we're seeing in Canada is that politicians are calculating that they will get more votes by targeting the tiniest and most vulnerable population of people in the country, that is transgender children, then they will lose by attacking equality rights. So if their gamble is right, we're in big trouble. We're really in really big trouble. You probably all know this, or maybe you do, I'm not sure, but the background to the 5-alarm fire piece of it is last summer, New Brunswick decided, little old New Brunswick, decided that they were going to change the policy in the schools to require that parents be notified if their kid was either wanting to use a different pronoun or a different name. It was so controversial that some of the cabinet ministers resigned over it at the time in New Brunswick. Saskatchewan, seeing a good thing, followed suit. I have to say, I come from Saskatchewan. When it's good, it's really good. It's NDP. When it's bad, it's really bad. It's very right wing. And at the moment, it's really bad. So Scott Moe, who is the premier of Saskatchewan, decided to literally follow suit. Said, we have a new policy now, and this is what it is. And for backstory, in neither province had anybody identified the existence of the then current policies as a problem. I think that in Saskatchewan, they talked to 3 parents or something, like that just literally was no groundswell. They cooked this up in their political cauldron. In Saskatchewan, a group called You Are Pride went to court and said, hey, wait a minute. You are discriminating against a tiny population of the country by the policy you just enacted. And when you do that, you're going against the equality guarantees in the Charter of Rights. Don't worry if you don't understand that sentence, we'll come back to it. And the court said, that's right, and struck down the policy, which they are able to do. Scott Moe, undeterred, Scott Moe's the premier of Saskatchewan, Scott Moe was undeterred. And so he passed a law. Now, listen to the difference between a policy and a law, okay? So the law gets passed by the legislature. He passed a law, and the law said, notwithstanding the equality rights that are guaranteed under the charter, and then he just repeated those pronoun and identity policies that had been thrown out. I'm going to leave you with a little bit of a cliffhanger there. Moving on to Alberta, Danielle Smith never wanted to be outdone and decides that not only is she going to do pronoun policies in school, she's going to go further, and she's going to wade in and start prescribing, not legislating, prescribing what care doctors can provide to trans youth. And she said, I don't care what the medical standards of care are. No child is competent to consent to gender affirming care. Therefore, no physician can prescribe it. That is, you know, I always have to stop here and gasp to think that it would be a political calculus that you thought you were going to win to insert yourself in the relationship between a doctor and their patient, which is, anyway. Smith says that they'll ban puberty blockers and hormone therapy for people who are under the age of 16, that they can't get surgeries except unless you're 18, and so on. Now, so that's the kind of legal and capital P political backdrop. Meanwhile, back at the ranch, and I think, Goose, you referred to this, across Canada from starting about last August, September, the organized transphobes, and I don't really have a better word for them, but the people among the organized transphobes are the metaphorical sons and daughters of the anti-vaxxer crowd. Some of them are literally the same people. And they organize. Now, I want you to kind of pause and think about exactly how much A, resources, and B, organizing would be required to pull this off. They organized in September and October simultaneous demonstrations across the country, including 20 in British Columbia. Now, I cannot frankly imagine trying to pull off organizing that at that scale. The other thing that it would have taken was a hell of a lot of money. But the fact that they both thought about doing that and were able to pull it off means that there is a depth of a kind of political undercurrent that is to me, it's the Trump tsunami. It's that mindset and that approach that is coming to Canada. So that happened. There were two everywhere demos, one in September, one in October. In British Columbia since then, there have continued to be variously demonstrations, targeted attacks on trans teachers or on teachers who teach the SOGI curriculum, complaints about content of school libraries, attacks on school boards and school trustees, like showing up and disrupting school board meetings, for example. And so it's pretty clear that the next or the current focus of the attacks is on the school system. And this is all done in the name of parents' rights. Now, I think they're brilliant. I can't imagine a better way to sell something than to call it a parent's right. because parents' right immediately also makes you think of your parental responsibility, right? And it makes you think of the well-being of your kid. And by this time, you're 90% behind me, just with that one phrase. And the parents' rights rhetoric, most importantly, sells well in the paying no attention crowd. The people who might read one article in a newspaper and that phrase comes up, and that's something you just agree with, you just agree with. So that's kind of the political backdrop. Here in British Columbia, there are, I'm sure there's way more than this happening, but there are at least two groups. One of them is called the Flying Squad Against Transphobia, and that more or less came out of the labor movement. That body monitors what the right wing is up to, identifies new sites of demonstrations or attacks of one kind or another, and sends a flying squad. If there's going to be a rally or a harassment, sends a squad there. The others is a group that I was part of setting up in the fall called Lawyers Against Transphobia. And one of the things that Lawyers Against Transphobia is doing at the moment is we are writing a handbook for school boards about how to deal with transphobes who disrupt the meetings, make demands about the curriculum, harass teachers, et cetera, et cetera, et cetera. So that's kind of and I'd be interested to hear what that's the snapshot of British Columbia. What's the snapshot in other places about what form the attacks are taking and what forms the resistance is taking? Anybody?
I can go.
Hey.
Even though I'm currently in BC, I'm originally from Newfoundland. And I would say that a lot of at least what I was seeing was very similar to in BC, going after school boards. And like there was this really big thing about like trans kids using like litter boxes in like schools. It was like ridiculous. So yeah, like that's the kind of like rhetoric that's like going on around there. Yeah, so very similar to what's happening in BC, targeting trans youth, but specifically schools.
Anybody else? Goose.
Yeah, so in New Brunswick, earlier last year, this would have initially taken the form of primarily anti-drag protests. So folks in a lot of cities set up drag defenses. There was a very successful one in Moncton in May. So that would have been the start of us definitely thinking that there was going to be more sort of coordinated attacks from the right. At the same time, we had some folks who were watching, like again, sort of convoy and conspiracy people because they had successfully organized in the last couple of years. So we had a good idea of when they were getting ready to protest. So we organized counter protests against them in September. They promised to do one a month later in October. And we took the space and prevented them from doing that in October, which is good. Additionally, there's an ongoing legal challenge. I am not the person to speak to the details there, but I do know some folks who are involved in the legal challenge in New Brunswick, and if anybody wants to know, I can post contact info and have them answer questions or get in touch. And there is some also de facto resistance in the schools to policy 713 with several teachers or school execs refusing to comply with the policy. additionally, it's in our case not super popular inside the Conservative Party. About 1/3 of Conservative MPs have either chosen not to run for re-election or have stepped down. And we intend to continue to pressure them to make more of them step down. But yeah, that's the work here. Thanks.
Thanks, Goose. What's happening to the teachers who are refusing?
Nothing yet. It seems like for the nothing that I've heard of, I should say, but so far it's been going okay. We haven't heard of any huge disciplinary action.
Thanks. Celeste.
Yeah, I can talk both about the resistance a little bit more at the nationwide scale as well as in Quebec. So here we've had a
I'm having a similar problem, so if you could speak slowly, that would be helpful.
Yeah, sorry to have of mine. So here in Quebec, we've had a lot of like new grassroots initiatives popping up in order to defend queer and trans community. So a lot of the anti-trans movement has developed very late here because Quebec being francophone now oftentimes is just much slower than the rest of Canada when it comes to sort of, in a way, contracting America's cough. So here, it only began in April last year, but in a few months, there was a pretty big network of drag defenders who eventually rebrand themselves as trans defenders to help defend fellow community members from anti-trans hate a little bit everywhere. And it's something that's grown quite a bit in numbers to the point where there's been no need to defend any community events since October last year because so much of the hate was successfully suppressed to the point where it's just no longer really a big issue anymore. However, I must say that anti-trans hate has definitely captured our government's attention, and they are now openly attempting to quote unquote listen to both sides, and also they're currently planning on introducing regulations to ban mixed gender washrooms in schools. So a lot of the same talking points have been recycled, but there are people, I'd say especially at the grassroots level, who are demonstrating against that and who are taking action to say no to hate.
Thank you very much. That's yay, Quebec.
Barbara, can I jump in and read something from chat?
Yeah.
Nicola has an offering as well, just saying that in the West Kootenays, one of the key spreaders of disinformation is running in a school board election, and that local community is organizing around getting an alternate candidate.
Yeah, it's really true that school boards are the big target here in BC, and particularly in the Kootenays and the interior. It appears that one of the strategies is to make it so unpleasant for SOGI supportive school board members that they won't run again. And so, for example, a school board member had posters plastered all over town with her image and a bunch of the books that the anti-trans folks say should be banned, with some scurrilous message on it. So it becomes hard to go to the grocery store, like in a small town. So that's another piece of what's going on. Okay, so that's the roundup. Now I'm going to switch to the Canadian Legal System 101. So the first thing to know is that in Canada we have a federal system, and what that means is the power to make laws about particular things is divided up between the federal government and the provinces. So and that's that division, the who gets what of it, is set out in the Constitution of the country, Section 91 and 92 of the British North America Act, so-called. And that means that the federal government can't make laws that are about things that are provincial on that list, and the provinces can't make laws about things that are federal on that list. Needless to say, there are some times when each body says, no, no, that's mine. And so they go to court and have a court fight about it, goes to the Supreme Court of Canada, and the Supreme Court of Canada said, okay, for this thing, this is where we draw that line. So principle number one is exclusive ability to make laws within the sphere that's designated under the Constitution. Okay. The next thing to know is that the process of making laws is different for the feds and for the provinces, because the feds have a two-step system. First, a bill is the name of a law that has not yet been passed. A bill goes through the House of Commons and then it goes to the Senate. So it's a two-step process. In theory, and very occasionally, in fact, the Senate will will refuse to pass legislation or will send it back for amendments or whatever. But the biggest power is in the House of Commons. In the provinces, on the other hand, there's no Senate. There's just the legislature. And the people who are in the legislature at any given time are people who have been elected. As in British Columbia, we call them members of the legislative, MLAs, members of the Legislative Assembly. I think in Ontario, it's MPP. You know, they have different names in different places. The process of a law becoming a law is a draft of the law gets presented, and generally it takes 3 steps. So step 1, step 2, step 1, it gets presented. Step 2, it gets referred to committee. The committee looks at it in detail and thinks about how it connects to other laws and that kind of stuff and brings it back. And step 3, generally speaking, is yay or nay. There's a vote and it's yay or nay. And of course, there's lots of politics around it. There's particularly lots of politics if the ruling party does not have a majority in the governing body. So look, currently in the federal government, the Liberals do not have the necessary majority unless they get the support of the NDP, or in a much less likely result, the support of the Conservatives. So and federally, what the NDP and the Liberals have done is make a deal that the NDP will support the Liberals, provided that the Liberals, and in this case, it comes through with pharmacare. And that often happens. Sometimes there's only 2 parties in a legislative assembly. Sometimes there's 2 parties and a little rump party of some third variety. But the rule is that you've got to get a majority of people in the legislature to pass the law. Once it's done that, and federally, once it's been through the Senate, then it becomes a law of British Columbia or of Canada, as the case may be. Any questions at this point? I do really well with questions. In fact, I used to say I can't talk for more than 5 minutes without a question. So if questions occur to you as I go along, just ask. We're good so far? All right. So then,
Sorry, Barbara, I think Lily had a question. Is that okay?
Sorry, Lily.
Thanks,
Okay.
Lily.
Yeah, quick question. I'm curious what role like the premiers or the prime minister plays in any of this process.
Really good question. Unlike the United States, where they elect their president separately from the parties, in Canada, the person who is the premier because they are the leader of the party that has the most seats in the House or in the legislature at the time. So occasionally there's a dispute about who that person is. I mean, you can imagine a situation where there might be an argument about that, but and also differently than the United States, the that leader consults with their caucus, and their caucus is all the members in the legislature. They also have a cabinet, and a cabinet is kind of like a group of table officers, each of whom has responsibility for a particular portfolio, like the Minister of Labor, the Minister for the Status of Women, whatever it is, Minister of Health. And the Premier or the Prime Minister has the ability, first of all, to decide what those seats are going to be, like how many people in the cabinet and what their portfolios will be called, and to decide who's going to be in that cabinet. And in the cabinet, being in the cabinet gives you a really big amount more power than your fellows who are not in the cabinet but are in the legislature. So being a cabinet minister gives you a fair amount of authority, particularly in relation to the portfolio you have, but also more generally, because at the cabinet table are discussed the kind of issues going forward, the main issues that is facing, the priorities that are facing the government, those kinds of things. That's a really good question. Anybody else? Okay, so criminal law specifically is, in Canada, who gets to make criminal laws? The feds or the provinces? Okay, is the criminal law the same in Alberta as it is in British Columbia? Yes, it is. The criminal law is a federal responsibility, and the criminal law applies across the country. So one of the specific things about criminal law that makes it tricky is that the federal government may from time to time dislike conduct and say, this is outrageous, we're going to make it criminal. Can anybody think of a quick example in our women's lifetimes? That would be abortions. So one of the ways that the federal government tried to deal with abortions was to say it's criminal to give a woman abortion unless, and then they had set up therapeutic abortion committees. There's lots of court cases and lots of court fights about when the federal government has gone too far in trying to exert its criminal law power to govern things which otherwise would have been in the bailiwick of the provinces. The bailiwick, the provinces, here's the one-liner about what the provinces get to rule about. They get to decide about, quote, property and civil rights in the province. Now, how much more broad could you expect that to be? In our constitution, where something isn't specified, it goes to the feds. By contrast, in the United States, if it's not specified, it goes to states, which is why you hear states' rights all the time. Really different here. I'm going to talk a little bit about I'm going to ask you, what was it? A couple of people said that they didn't know much about criminal law. When you said that, what did you mean? Did you mean like how it works in practice, that people get charged and go through the system, or what did you mean?
I can answer part of what I was struggling with. I think that my biggest challenge, knowledge gap, was what you talked about, Barbara, of like, what is a bill and what is legislation and what is the process that those things become law. I know that like sometimes I would see like this bill, and then our community would be really concerned, and then we'd be hearing, okay, it's not a law yet. And that sort of like journey into what is the law was like a really big gap for me. And I definitely did not know that piece. I just put in the chat about the difference between the US and here of like states' rights, and how the feds have a different kind of power. It's so interesting. I did not know that.
Yeah, Tess.
Yeah, I guess when I say I don't fully understand the big picture about legal, I mean, you mentioned the notwithstanding clause earlier, and I guess I don't understand why it's such a invulnerable gotcha, you know, why there's, I don't know, maybe you were going to get to it because you said you're going to talk about it later, but that's the gist of what I was saying.
Yeah, thank you for that. It is actually the most important question of today's seminar, which we're going to get to. Does anybody want to know about, so when that process of going through the legislature, they're called bills, and bills can, quote, die on the order paper. And what that means is they got introduced, but the session ended before they got passed. And then they have to be reintroduced at the next session. Does anybody really keen to know about charging and that kind of stuff? If not, I'll skip that for the moment. Somebody does want to know that?
I'm
Or
very interested in that. Yes, thank
Oh,
you.
you're interested. Okay. This is really quick and dirty because for one thing, it may differ province to province because the provinces, though the criminal law is federal, the administration of justice is provincial. So the province might have different ways of doing, your province might have slightly different ways of dealing with things than ours. In general, if somebody calls the police and says a crime, the police will attend or not. They have a discretion. When the police get there, they will assess the situation and they will, or they are allowed to, do a number of things. Depending on the severity of the crime, they can arrest people. If the crime is not so serious, for example, if it's jaywalking, they can't arrest people. First of all, jaywalking is not actually a criminal offense. But let's take something is criminal, but mischief. Somebody puts graffiti on the side of a building, they get caught. They're not going to get arrested for that because it's not an arresting type offense unless they've got a criminal record. Then the Crown, if they arrest you, they'll take you to the cop shop and you will be released either at the time you get to the cop shop or shortly thereafter, or after you appear in court the next morning. And the general rule is that the criminal legal institution should not detain people before trial, except where it's necessary for public safety, essentially, or to ensure that an accused person will show up for trial. So if you've got an accused person who has got a string of FTAs, failure to appear, they're much more likely to be remanded, it's called. Remanded means put in jail until a hearing. They can be released on a number of, a kind of graduating set of conditions. One is like a promise to appear, which is exactly that. Yeah, I'll show up. It matters that you've signed a promise to appear because if you don't show up, then you can be charged with that. You can on your own recognizance, meaning you don't have to put up money. You can be released on bail, which means that you have to either provide or demonstrate that you can provide a level of financial of money available, which will be sacrificed if you don't show up. So if somebody's putting up bail for you and you don't appear, then they lose their money. Those kinds of, like, there's a whole range, but the general principle is the person should get out unless there's a compelling reason to keep them inside, either for public safety or to prevent them from not turning up again. In some places, the Crown, the police approve the charge. That means they look at the facts, they figure out what charge in the criminal code those facts will support. And they charge with that. And in some places, the charge is laid by the Crown. And the Crown is the name that we give generally to the lawyers who are hired by the provincial government to prosecute criminal offenses. So Crown Counsel or the Crown. And notice the colonial references. So does that help in terms of criminal process? People are entitled to a phone call. They are entitled to legal aid in depending on the funding for legal aid, the eligibility requirements will relate to a combination of how much money they have or don't have, and the likelihood that upon conviction, they'll end up going to jail. The Indigenous people have some accommodations in the criminal justice system, which is probably beyond today's workshop, but you should know that. And I'm going to stop there. Alicia, you have a question.
Yeah, I have a few. You had mentioned that police forces have discretion between responding to calls or not, depending on what it's about. And I'm curious about who defines that discretion. And I'm also curious about how municipal policing bodies, so for example, here in the Lower Mainland, we have the Vancouver Police Department, and then Surrey Police has just started as well. And I'm curious about like checks and balances, because if criminal code or criminal law is determined by federal bodies, how do they make sure that that's trickling all the way down to municipalities?
The answer to the question of who gets to exercise discretion is, I don't know, whether it's the Crown or whether it's the police, and it might be different in different places. What was your next one?
How are municipal policing bodies, I guess, held to a
Okay,
certain level of
you know what,
attention?
I happy to talk to you about that, but not going to go there today, just because it's kind of outside where we're headed. Did you have another one? Or did I? Okay. All right. So, that we care about the criminal process for two reasons. One is we might get charged if we're at a rally, and the other is the cops won't charge the trans folks. And there's a section in the criminal code about hate speech, which I will talk to you about. And the hate speech section requires a particular kind of review before the charge is laid. And it is our experience here in BC that the RCMP in particular are basically hopeless at recognizing or enforcing the hate speech provisions of the criminal code as they relate to trans folks. Now I noticed that it's 4 o'clock, and that seems to me to be a pretty good time to let's have a little 5-minute break. And I'll come back and we'll dive into, and so what we're going to do when we come back is I'm going to talk to you about what the Charter of Rights is, what human rights legislation is, and how those fit together. And then we'll talk about how they connect as in terms of our strategies moving forward. Okay, let's come back at 7 minutes after 4.
See everyone then.
Oh, you're muted there.
I talk with my hands, but that's ridiculous. Remember I talked earlier about the division of powers between the feds and the province being set out in the Constitution. The other thing that's in the Constitution is something called the Canadian Charter of Rights and Freedoms. And that that section of the charter has a whole bunch of guarantees, for example, freedom of speech, freedom of association. For our purposes, the most important rights are Section 15 of the charter. Could you please somebody put that on the screen for me?
I'll do it right now.
So what the charter says, and this is one of those ones where it really actually matters to read it carefully. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. What's the first thing you notice about that section? No protection for queer or trans folks. When the framers, the Charter of Rights was added to the Constitution of the country in 1982, and it was done by agreement. And had they included protection for queer folks at the time, we would not have had a Charter of Rights. So does that mean that we're out to lunch? We're done? We don't have any rights? All you legally minded folks, read it again. It says, entitled to the equal protection and equal benefit of the law without discrimination and in particular. Without discrimination, and then there's the list. And the Supreme Court of Canada has said those words "and in particular" mean that the list of protected grounds is not closed. Any group of Canadians who can demonstrate that they are part of a historically marginalized group can claim the equality rights protections of Section 15 of the Charter. Why do we care? Well, first of all, let me just do a teeny weeny little history thing, which was back in the bad old days, in the early 90s, as these charter cases were beginning to be litigated, we queers did not know, number one, whether the Supreme Court of Canada would decide that other marginalized groups could be included. Number two, if they did, whether that would include queers. And number three, if it included queers, would it include us only as individuals, but not as to our partners or families? Happily for us, the Supreme Court of Canada answered all those three questions in the affirmative. It was not until last year that the Supreme Court of Canada had its first occasion to talk about whether trans people are protected by Section 15 of the Charter. And they said, yes, trans people are. Now, what's the difference between having that guarantee in the Constitution of the country as opposed to in any old piece of legislation? Well, there's two important answers. The first is, if it's in the Charter, if it's in the Constitution, no one government can change it. That it can only be changed by like a and there has literally not been a constitutional amending thing for decades, because it's so difficult to get the right number of provinces with the right percentage of the population in favor. Second, and this is huge, if we can show that a law violates the equality rights section of the charter, then the court has the power to throw out the law. It also has the power to fix the law instead of throwing it out. For example, my favorite example, Alberta, wouldn't you know? About 20 years ago, they passed their first human rights legislation. And in passing that law, the legislature explicitly excluded queer folks because we were like Jeffrey Dahmer. We were cannibals, we were pedophiles, I mean, it's gross. An Alberta group went to REND, actually, the case is called REND, went to the Supreme Court of Canada to say, you can't do that, Alberta. And the Supreme Court of Canada said, you're right, REND, they can't. If you're going to make a law that protects most of your marginalized people, you cannot further marginalize one of those groups of people by refusing to include them. And the Supreme Court of Canada just added sexual orientation to that, to the Alberta legislation right on the spot. So they have the power to do that. However, this is a truly Canadian provision. There is a provision in section 33 of the charter that says, if a government wants to pass a law that would violate the equality rights of its citizens, even though it violates the equality rights of its citizens, then they can choose to do that by using the Notwithstanding Clause. And the Notwithstanding Clause, which is in section 33 of the charter, says
Alicia, sorry, Alicia, we can see your screen. Can you just go back to the charter for us? Thanks.
That the Notwithstanding Clause says that provided that a government explicitly says in its legislation, we're doing this even though we know it contravenes the charter. In other words, we're doing this notwithstanding the Charter of Rights, then that law passes and it erases the equality rights of the citizens with respect to that law for 5 years. The law dies automatically after 5 years and has to be reenacted. That is exactly what Scott Moe did. He got his legislature to pass the very same policies, except now they're laws, through the provincial legislature. And that law includes a provision that says it operates notwithstanding the equality guarantees in the charter. So, are we dead yet? I told you that, or maybe I didn't, I think I forgot to say this. At the time that the charter was enacted, the framers of the charter gambled that it would be so politically toxic for a government to enact legislation notwithstanding the charter that they wouldn't do it. In fact, that's largely been true. Most of the uses of the charter to cancel equality rights, there have been about 4 cases in Quebec where they were used, for example, to cancel language rights, and they were used to be able to pass the law banning the wearing of, quote, religious symbols like hijabs and so on. So Quebec is the province that has used that clause the most. And but here we come. Now, what to me, and this is, here we are at the 5-alarm fire part. If Scott Moe gets away with, when I say gets away with, is not defeated in the next election because he used the notwithstanding clause in the legislation. If his government survives, it will signal to Danielle Smith, to Doug Ford, to every other conservative premier, past, present, or future, and by the way, any other conservative prime minister, who will then use the notwithstanding clause for whichever of their pet projects they want to slide by, notwithstanding that they are discriminatory pieces of legislation. So it is my prediction, it's one I hope I'm wrong about, that within it, if Scott Moe doesn't go down for this, then within a generation, we will have lost all of our equality, our constitutionally guaranteed equality rights. Now, do you understand now what the notwithstanding clause is? Anybody with a question about that? So remember, the Charter of Rights itself includes the provision that enables governments to cancel people's equality rights by passing a law that includes the notwithstanding clause. It includes a declaration that they're doing it on purpose, notwithstanding the equality rights in the Charter. Now, the Charter only applies to government action, which means laws passed by governments or bodies that are created by statute, BC Ferry Corporation, for example. Anything that is created by the legislature is susceptible to being challenged under the Charter. What about our rights in relation to each other or to the private so-called sphere? Now, can I please have the human rights slide? Every province has a law. It's not necessarily called the same thing in every place. But in BC, it's called the BC Human Rights Code. I think in Alberta, it's called the Individual Rights Protection Act, and so forth and so on. So, now, it's a provincial law, so it's not part of the Constitution. It's like a law that the legislature passed. And by extension, the legislature can revoke it. It is a law that governs the relationships between citizens and the relationships between the citizens and the government. For example, suppose I'm on social assistance and the ministry enacts a policy that says if I have somebody who is staying with me and sleeping with me, they are my common law spouse, whether I say so or not. And that means that my social assistance will be reduced and we will be paid at the couple rate. Now, on the face of it, that discriminates against anybody who's living with a roommate, for example. I mean, it's discriminatory on its face. So in that case, we have a law that is on its face discriminatory. We therefore have a choice. We can either challenge the law itself by making a charter, doing what's called a charter challenge, and that involves going to court. Or we can file a human rights complaint that says, I have been discriminated against by the government in its provision of services because. Now, let's look at what the Human Rights Code does. It says we protect a person must not, without a bona fide and reasonable justification, A, deny to a person or class of persons any accommodation, service, or facility customarily available to the public, or B, discriminate against a person or class of persons regarding any accommodation, service, or facility customarily available to the public because of, and here's the list of covered grounds, indigenous identity, race, color, ancestry, place of origin, religion, marital status, family status, physical or mental disability, sex, sexual orientation, gender identity or expression, or age of that person or class of persons. Note, not all human rights laws across the country, they all include gender identity. They do not all include gender expression. I'm not going to go into the exceptions there. There are other sections of the code that apply to, for example, tenancies, memberships in unions, purchases of property, and so on. But this one relates specifically to it's the most commonly used, the provision of an accommodation, service, or facility customarily available to the public. So what do you do about that? If you have a discriminatory situation, what do? You file a human rights complaint, and a human rights complaint is filed with the Human Rights Tribunal. It is, and those systems are a little bit different province by province. They all are based on tribunals, but they don't all have the same tribunal structure. A tribunal is like a court, except it's kind of it's like a court, but it has less prestige. So it's called an administrative tribunal, and they get to make orders. They get to make orders which are as binding as orders made by a court. After you filed a human rights case, then you can I don't know what the end of that sentence was going to be, so I will move on. I was thinking ahead of myself at the same time. So the other thing that is protected in BC, but not everywhere, is I call this the hate speech section, although that's a little bit sloppy because it's not exactly hate speech. Could you move it down so there we go. A person must not publish, issue, or display, or cause to be published, issued, or displayed any statement, publication, notice, sign, symbol, emblem, or other representation that A, indicates discrimination or an intention to discriminate against a person or a group or class of persons, or B, is likely to expose a person or a group or class of persons to hatred or contempt. So in relation to the second of those, the B, there's a very famous case in BC called Auger and Watcott. And what happened in that case was Bill Watcott, who literally has spent his life going around being hateful around and getting sued for it. And he, in this case, Morgan was running in Fairview, Mount Pleasant for the NDP, and Watcott plastered the riding with posters that said things like, "She's really a man." I mean, there were vile posters. God doesn't believe in transgender. Those, I mean, we've all heard the tropes. Morgan lost. Morgan filed a complaint under this section of the Human Rights Code against Watcott. And the decision that the Human Rights Code rendered in that case is enormously useful for not only in BC, but for any province where you do have protection against hate speech. Auger is the case to read, because they have a truly wonderful analysis of the circumstances of trans people, of why for example, misgendering someone is hate speech, and so on. It's really worth a read. And I'm going to put the name of that case in the chat. And then I'm going to tell you, there is a free database that is called Canley, and that's spelled Canlii. If you Google it, you'll find it, and you can look up any case in Canada. It's a pretty straightforward user interface. I don't have any trouble with it, so there's your guarantee. And it's a really very useful resource. In another case, a separate case, Adrian Smith, who's a well-known trans lawyer here, went to court on behalf of an employee whose boss refused to deal with the trans worker's co-worker who persistently misgendered them. And that case held that, number one, misgendering is automatically discriminatory, and number two, the boss was on the hook. In addition to the co-worker being on the hook, so was the boss, because the boss has a duty to maintain a harassment-free workplace. So that gives you, I can tell you, I did, for a case I was working on, I started this little project, which I thought was going to take me like a couple of hours. I went to Canley and I put in the search engine, I put transgender or gender identity, and limited my search to the last year, thinking that would give me maybe, 5 or 6 cases. Up came a couple hundred cases. They were not all about trans issues. Some of them just had the word gender identity in the Human Rights Code that they were quoting for some other purpose. But there is an explosion of case law relating to trans people in family law, trans people in criminal law, trans people in human rights law, trans people in health law, and all of it, 100% of it is on our side. 100% of it. So, for example, there's a great case out of Ontario that says if somebody harasses is disruptive to a school board meeting, the school board has the right to kick that person out and refuse to let them come back, that kind of stuff. Now, let's go back to the political context for a minute, the small p political post-convoy situation that we're in. We are in some ways, we're in a defensive position because the transphobes are attacking school boards, they're attacking drag shows, they're attacking, you name it. And in some ways we can be in the offensive position. So in the offensive position, for example, if I have somebody who is saying, John Smith, teacher, is a pedophile because they're teaching Soji 1, 2, 3, then knowing what you know now, what can I do about it? I can file a human rights complaint against them and say that in making that post, they are in violation of section 7(1)(b) of the Human Rights Code, because what they've said is likely to expose a person or a group or class of persons to hatred or contempt. I can also, anybody got any other ideas about what you could do? What do you do generally if somebody like says something scurrilous about you? Defamation. You can sue for defamation. Now, suing for defamation is a pain in the ass. It takes forever. It's expensive. Though the court might ultimately agree with you that, yes, that was defamatory, they might also make an award of damages of $1. So you might spend lots of money on lawyers and not get any of it back, essentially. However, well, no, and defamation suits are one of the ways that the bad guys have been using to shut down the good guys. So, and this has particularly been true in the environmental context. Somebody says, you know, tree destroying company A is ruining Vancouver Island. Then tree destroying company A files a defamation suit against the person who made that post and says, you can't say that because it ruins our good reputation. There is a new law, and it exists at least in Ontario and BC, and I don't know about the other provinces, called anti-SLAPP, SLAPP, Strategic Litigation Against Public Participation. So the defamation suit that tree destroying company brought against good guy poster is an example of a SLAPP lawsuit, because they actually don't care what the outcome of that lawsuit is. They know that if they sue you for defamation, your lawyer's going to tell you not to say any more about it or risk further damages down the road. So it's basically a shut up move on their part, recognizing that that had the consequence of shutting down public debate. The BC government, the Ontario government, and maybe some others passed law that says if, and I'm going to give you the actual example because it's easier to work with. Neufeld is an asshole school trustee in Chilliwack who said horrible things about SOGI 123 and trans people and stuff like that. Hansman was the former president of the BC Teachers Federation and himself a gay man. He said of Hanson's comments, of Neufeld's comments, Hansman said to the press, those comments are hateful, transphobic, damaging, and so forth and so on. And Neufeld then sues Hansman for defamation. The shutdown move, right? But no, now we have the anti-SLAPP law, and it says Hansman can go to court and make an application to have Neufeld's defamation case shut down unless Neufeld basically can show that he's certain to win. Now that's a vast overstatement but it means that we can put them back on their hind legs and make it difficult for them to pursue the shutdown move. Because if I'm successful in making my anti-SLAPP application, the outcome will be that this case can't go forward, and therefore I get to say what I want. And that's what Hansman did. That's when Hansman took that PPPA, Public Protection and Public Participation Act application against Neufeld, and that made its way all the way to the Supreme Court of Canada. And it is that case in which the Supreme Court of Canada, for the very first time, decided that trans people are a protected group under Section 15 of the Charter. Everybody with me so far?
Barbara, I'm just going to read one comment from chat
Mhm.
pertaining to the anti-SLAPP piece. Nicola referenced something that we at Salal see a lot too that I just think is important that we mention is that it's also threatened by those who've been accused of gender-based violence or sexual assault. So threatening to sue the victims or the community members who are vocal about confronting that behavior. And Nicola, thanks for adding that. That's a great point.
Yep.
And then I see Alex has a question as well, if you're okay.
Yep.
I was just wondering if there's like any possibility to like to use like the human rights code, but like do it in an anonymous way. So just thinking of like trans folks who might like apply as like saying like their employer is like violating their human rights, but then that puts them at like higher risk for like being even more discriminated against and like attacked personally. So is there a way to like use the human rights code, but in a way that like protects the person who's also like trying to use it for them?
The answer is yes and no. It's possible to get an anonymization order from the Human Rights Tribunal, but that only means that the public other than the parties can't know who you are. Because the employer or whomever needs to have enough information about the complaint to be able to respond to it. So, and if you're an employee, it's extremely unlikely, I think, that you would be able to file a human rights complaint and stay anonymous regardless, especially if it's a trans-related one. But so the quick and dirty answer is no, you can't effectively make a human rights complaint against your employer, which is going to keep your identity from your employer or your landlord or your whomever. Just parenthetically, in my entire career, I have never seen anybody successfully file a human rights complaint against an employer where they are currently employed. Because when I say successfully, I mean still be employed at that employer after that human rights case is heard. Because it's just too hard. Human rights processes are extremely grueling for people, extremely grueling and emotionally grueling. And that's true when there's nothing special about it. When it's your employer that you're complaining about, forget about it. Like, it just is way too hard. So I actually advise people who ask me about filing against their employer not to do that unless they're going to leave first. Anybody else questions about human rights? Okay, so I began to say, we want to be able to be on the offensive, not only on the defensive. It's of course important to know what the good defensive moves are, but it's also important to know how to go on the offensive against transphobic conduct. So, and that's what actually one of the things that we're writing about in that handbook for school boards that I mentioned to you earlier. What are the options available to a school board if somebody's turning up and harassing folks and preventing business from getting done? And they have a whole bunch of options, including there's a section in the School Act that lets them say, you can't come to school board meetings anymore, for example. They can file, they can ask for the assistance of the RCMP because once they've withdrawn their consent for somebody to be on their property, then it's trespass. And so forth. So there are a number of pieces available to them, to school boards. Having said that, all of the pieces are cumbersome. And none of the players, I think it's fair to say, I mean, this sentence hasn't come out of my mouth like this before, but I think it's correct. The assault, the transphobic assault, is an assault which the likes of which we've never seen as an assault on Canadian institutions. And it is an assault, therefore, for which nobody is really adequately prepared. For example, teachers in schools are now getting targeted. Teachers have belonged to a trade association called the BC Teachers Federation. Same is true in all the provinces. But at the moment, that harassment is being dealt with like any other grievance under the collective agreement, and that means, among other things, that there's not a coordinated provincial strategy. So I think that we urgently need to be making provincial strategies on all and cross-provincial strategies about all of these things, so that we are able to respond with some degree of effectiveness. Somebody said to me not long ago that trans teachers who are targeted, every single one of them of whom this person was aware, and they were in a position to be aware, was now on LTD because there was no effective way to deal with the harassment. It's also, there's a particularly difficult kind of harassment, which is teachers in the school, person unrelated to any of their students, so therefore no connection to the school, starts online targeting the teacher, maybe publishing their name, address, showing photographs, you name it, publishing it all to libs of TikTok. You get the picture. All of a sudden, it's really dangerous, and it's like not in the quote employment context. It's targeted at the teacher in the teacher's so-called private life. So figuring out how to shape a legal response to that is not straightforward. It's particularly consider another wrinkle, and the harasser lives in a province that's not the same as the province that the teacher lives in. We've got jurisdictional questions. So I'm gonna stop there with the description. Well, no, I'm not. I'm gonna say a little minute more about what I think needs to happen. And then what I'm gonna do is to hear from you folks about how this is landing with you and what you would need to move forward and those kinds of things. Pardon me. On the positive side of this awfulness is this fact. I've been doing like community organizing like this kind of for 35 years. And I have never encountered the degree of, oh yes, please, I can help. I'm with you. Tell me what to do. Let's organize. And it like the kind of immediate, unqualified recognition of the risk and determination not to let it happen has really been quite stunning to me. like really stunning. And I am confident most days that the good guys in Canada are in the majority. I'm confident about that, however, with some reservations. And I'll tell you when I got really nervous about whether I was right. And it was when Pierre Poilievre decided to include anti-trans positions in his platform. For a long time, he dodged it. And in my view at the time, he was dodging it because he could see that it was a loser of a position for him, which is of course all he cares about. He's now changed his mind. And so, I mean, I don't have the resources to do a complete analysis of this to know the answer, but if that's his calculus, then we got to be worried. And we have, and parenthetically, we absolutely have to defeat Pierre Poilievre. If we do nothing else, we have to defeat Pierre Poilievre. So work on the ground here in BC is really robust, and people's enthusiasm is not falling away. And the law is one of the mechanisms that we can use, only one. If we only use the law, we're not going anywhere. That the law is slow, it's cumbersome. It's not going to save us, but it's a part of what's going to save us. Like, it's kind of got, in a way, if you think of it as the law's got your back at the moment, and that's really good to know. So, and I put in the chat earlier that if anybody is interested in being on the mailing list for Lawyers Against Transphobia, I would be delighted. And also, I'm going to ask any of you who are in provinces other than BC, if you would be willing to report to me from time to time what's happening in your province so that I can include it in our mailouts, and so that we can maintain some kind of more national body than we currently do. There are lawyers from pretty much every province at this point, but certainly BC's got the bulk of us. So what are you, going forward from here, what's your takeaway from what I've told you in terms of, don't tell me this in the chat. You have to send me you have to send me an email. I'll put my email in the chat again, just because I can't do.
I'll send a follow-up email to Barbara
Okay, great.
to help you out after.
Thanks.
I'm also happy to answer your question first, if you like, about
Yeah,
what I'm going
go
to
for
take
it.
forward. I feel like I understand a lot more, and that feels like the objective I wanted from this workshop, to be empowered to talk about these things, feels achieved. But also the like burden of knowledge of like, oh, I'm scared in a different way than I was before. So just naming that, I think what I'm going to take forward is what you talked about being on the offensive and the defensive, and that piece tied back to how the bad guys, and I'm going to say bad guys, and I kind of stand by it, are really like targeting the people who are ambivalent and targeting the people who don't really want to do their research and don't really want to be involved. And it's like, those are the people also that we need to be engaging in conversation with, and inviting them to the table, and inviting them to join us in the work that's happening. And yeah, I think that that's what people with some privileges that I hold really need to be stepping up and doing. And then I also think I need to do more research. Like you do a workshop and you learn a lot, and then 2 days later you're like, oh man, and I have more questions. I have more questions after digesting. So making a commitment to continuing, and like not letting this be the last time I think about anti-SLAPP and about the legislation and about the clause and all of it, and just committing to doing that. I learned so much, Barbara. Thank you. Thank you so much for this.
Here's my offer to everybody. You can feel free to email me with questions into the far future. I'm happy to answer them if I know the answer.
Can I pass it? Would you like us to pass again, Barbara?
Pass.
Pass it to other people to talk about what they're
Oh,
gonna
yeah,
take
yeah,
forward?
please do.
Okay. Lily, can I pass to you? Thanks.
Yes, of course. I was going to volunteer anyways. This is perfect. Yeah, similarly, I'm feeling more empowered of like to know what the options are. It was news to me that misgendering is always considered harassment. And that feels really important to share further. Because I think some of that conversation got dominated early on by like Jordan Peterson and stuff. And so it's great to be like, that guy is actually wrong for a lot of reasons, but
Yeah,
also
no kidding.
really wrong about this one specific thing. So go fuck yourself. I won't say that, but that feels really important. And I think in general, like, I think this is like another round of reactionary right wingers targeting the most marginalized group because they need a scapegoat. They don't have policies or perspectives that they know a lot of people will support. And so they're trying to target the most vulnerable. Again, they do this every, 20, 30 years. And so it makes me think about ways that have been successful in the past of showing the importance of solidarity and the importance of humanizing us as queer folks and humanizing trans folks as a way to be like, you've heard all these really scary things, they're actually not true. And so as someone in the kind of education context, that makes me excited about ways to make change, and knowing that the law is also reactionary. It is not very proactive. And so knowing that as we're making those moves, there is a bit of a cushion for when things inevitably go sideways is where I'm at.
Thanks, Lee.
Thanks. I'd love to pass it to Alex if you're ready.
Yeah. For me, I think I'm walking away with more of like a foundational understanding of the legal aspect of it. I think I'm also and likely will be processing the information for quite some time. But more so in the like the notwithstanding clause, like that for me was like I was just like, could could that legally be okay? And I guess I have like more of an understanding of that now, but also that creates a little bit of like an internal divide. Like logistically, I understand it, but then morally and ethically, I'm just like, it still doesn't make sense. So I think I'll be walking away with like more reflection on that, and also more tools to advocate and like fight against this kind of stuff. Knowing about like the anti-SLAPP stuff, that was something that I was unaware of before. And just like the differences between being like in a defensive versus offensive position around these kinds of legislations. So yeah, I think that's kind of like what I'm walking away with. And I just want to say thank you very much. Like this has been very valuable. And yeah, I've really enjoyed this today's platform to chat and just connect with everybody. And I will pass it to Goose.
Yeah, I'm trying to summarize my thoughts, but I the legal analysis was really helpful. It gave me a couple of pointers for things to look at locally. I suspect that New Brunswick will be behind BC in many of these respects, as is very often the case. But that gives me some things to look at and some questions to ask my lawyer pals, which is good. Also, I it's nice to hear that. I think the points of hope and the points of caution are things that ring really true to me. It sounds like one of the challenges that institutions have fighting a lot of these people are the same challenges that we have, which is that it's a lot of this stuff is kind of networked or spontaneous, I guess. And so learning to fight that is difficult, but also means that there's a tremendous advantage for us to be able to organize in similar ways. So that's been really good. And I think that's it. Yeah, thanks so much. I really appreciate it.
Thanks, Goose. Who are you naming?
I will name Alicia if you're ready.
Sure. Thank you. You'll have to forgive me. I've just worked 7 days in a row, so my brain is jumbled, but yeah, I think I just need to echo everyone else's sentiment. This information was incredibly valuable. I feel like it gave us a really practical understanding of how to apply all of this legalese. Though I have a poli-sci background, I feel like a lot of the information that I learned here was new just because it is so specific to queer community and trans folks, which is a major gap, I feel like, in a lot of the learning that we face under these like capitalist colonial systems, I guess. So yeah, I will be spending a lot of time digesting, and I'm sure I'm gonna have to revisit this recording. But yeah, thank you all for being here, and thank you, Barbara, for having us. I'll pass to Tess.
Thanks, Leisha. Yeah, once again, thanks for the information. I think I'll talk about how this made me felt and what I want to do or what I feel we should do. And that's, I really feel like we need to figure out a way to flip the script of those who are marginalized from being stun-locked, paralyzed, or as we talked about in this call, on the defensive, to feeling energized, to organize and do more. You know, there's lots of people I talk to who I try to organize with who say things like, I can't, I just do this or that. And I know that in a lot of ways people are, you know, economically oppressed, and that's has to do with it. But yeah, finding a way to make people feel like they have the energy or they draw energy from organizing in order to address some of the issues that we talked about. And I know a few people in this call as well do community organizing, and a few people I learned about the organizing they do through this call, but I'm figuring out how to do more and more, build more networks between us, and learning about how to attack that multifaceted approach that Barbara talked about, where it's not just the law. You know, if we all work together, we can find out all the different ways that we could fight this. Because I don't know about y'all, but I think a lot about Pierre Poilievre and the majority that the Conservatives are trending towards. So figuring out how to make it unpalatable for them to talk about trans folk and the gender marginalized like the way they do, I think that is important. That's like the least we can do, right? If we can't defeat them in the federal election, at least we can make it so that they can't destroy us. So there's just some thoughts I had. Thanks. And I will pass it to Celeste. Is it okay?
Yeah, I'm home now, so like the audio should hopefully be better. So honestly, so I already do have like a legal background. I'm currently finishing up my law degree, and definitely a lot of this actually isn't new to me, but just hearing it in practice and hearing like how like us as a community we can like defend ourselves is definitely something quite new to me. And like I'm really glad to hear. Thank you so much, Barbara, for putting this on. I'd very much say the next step though is how do we get the general population to care about human rights? Because I've noticed that it's something that's pretty hard for us to convince. Like people, I know people within the legal sphere, especially the folks I hang out with, talk so often about, yeah, we have charter rights, we have so much more, but how do we convince the general population it's so important to like actually defend these rights and not just using the traditional argument of like your rights are my rights, are their rights, etc., etc., etc. I very much believe that that's going to be the next, sort of like the next frontier on our end if we want to defeat the notwithstanding clause. And it's not something that's going to happen from, like, in French, it's jour au lendemain, or like from today to tomorrow. I think the rest of the folks here have their camera off, so I'll let them decide who wants to speak next.
Hey, Sam.
Yeah, is it all right if I go next?
Yeah.
Yeah. I really appreciated it. I mean, everyone's said it before, but it's really true. This is incredibly helpful. Very, very like clear. And I'm so sorry I couldn't get here for the first hour. I'm in Eastern Standard Time, and God, it happens. But anyhow, yeah, I super appreciate that, and I appreciate knowing how strong a lot of the legal arguments and the legal standings that we have are. Because it's tough when you see how difficult like the public battle is, and spending so much time on that makes it, it makes it a more like a hopeful struggle, I guess, knowing that when you get that battle done, the legal battle is not like another, mountain, it's a hill. And I appreciate you giving the time of day to like get people together to do this. Yeah.
And honestly, what I've been, when I say 5 alarm fire, that's what I've been doing. I've been going around every single, like LinkedIn, Facebook, all those places, all those social media places, every time I give a speech, every time I mean, I just say it all the time. I talk about it all the time everywhere. And I talk about it all the time everywhere in a kind of, hey guys, you're gonna want to know this because we're about to go over the cliff sort of way. And I mean, in my imagination, I would love to see things like, oh, well, today's Trans Day, is today Trans Day of Visibility? Yeah, today's Trans Day of Visibility. So every opportunity that we have or can create or can hitch onto or to whatever. My inspiration comes from Margaret Mead, who said, never doubt that a small, committed group of individuals can create change. Indeed, it's the only thing that ever has. So large is not what you need. Like, to give you an example, I've never worked with a group of people larger than 12, ever. And 12 is big. More like 6 most of the time. And it's not like everybody can do everything, blah, blah, but it's like, don't be stopped by the fact that you don't have 300 people ready to walk behind you. The other thing this one I learned from my unlearning racism teacher, Gloria Yamato, who said, when I was expressing kind of doubt about my ability to do unlearning racism work as a white person, she said, well, fortunately or unfortunately, you're it. And it really hit me. It was like, okay, we are it. We are it. Thanks everybody for being here. It was really, really, really great to meet everybody, and I hope you'll stay connected.
Thank you so much, Barbara, for this workshop. Yeah, I think I can speak for everyone's facial expressions that seem to match mine. We're in it, but we're in it together, and what a friggin' relief that is.
Yeah.
I can commit to Leash and I probably Wednesday of next week can send the attendees an email, and we will share the resources that Barbara put in of how to find the cases and the cases she referenced, and your email, Barbara, if you'd like as well, just for attendees here. And then that way we can stay in touch and we can continue together to do this.
Great.
All right. Thanks, everyone. Have a great weekend.
You
Thanks
too.
for being here.
Bye for now.
Bye.